Unfortunately for me, this presentation is being recorded, and so probably tomorrow everybody that's registered will be sent an email with a link to the recording, as well as a copy of the slides. So don't feel that you have to sort of keep up making notes. So as I say, the topic of today's seminar is Adult Care, the Inherent Jurisdiction. And just to be clear, I will not be talking about the inherent jurisdiction as it relates to children. I will leave that for my family law colleagues. The only observation I would make, which may be of some assistance, is this. Where you're dealing with matters relating to children in terms of general principles, case law, and so on, there is often a read across. So often principles that apply to protecting children can be read across in respect of vulnerable adults as well. So it's just something to bear in mind, but I'm not going to go into detail about that. Is this going to work? Okay. So what is the inherent jurisdiction? Well, it's often referred to as the great safety net, which is a term actually coined by Lord Donaldson back in a case in 1990 called Re F. And I hope that it will become clear as we go through this presentation why it's referred to in that way. Really, it's about filling gaps and stopping people getting lost. I'm not going to give you a comprehensive history of the inherent jurisdiction. That could take days, I think, but just to give you a brief, more recent indication. By the 1990s, the position appeared to be that there was no what's called parens patriae jurisdiction in relation to adults. What that means is the power of the state to act as a parent or guardian for its citizens, or the legal protector of those unable to protect themselves. And the focus really was looking at the law of necessity and the Bolam test. This was primarily in relation to medical cases, which talked about necessity dictating whether or not something was lawful. So is it necessary to act in that way, and was that act one that a reasonable person in the circumstances would take? And that position really was confirmed again in the case of Airedale and Bland in 1993, of which you might be aware, Anthony Bland following the Hillsborough disaster. And in that case, the House of Lords said that the parens patriae jurisdiction of the High Court no longer existed. So there seemed to be sort of a fairly clear position at that point. And then we get to around 2000 and everything changed rather significantly. And of course, this was a point where the Human Rights Act was about to come into force. And there were two cases in relatively quick succession, a different Re-F than the one I mentioned earlier, and the case of Re-S, both Court of Appeal cases. And in Re-F, reference was made to the Human Rights Act, and in Re-S, the Bolam test was rejected, and it was confirmed that the jurisdiction was in fact founded on best interests. So there was one answer. If you're looking at a set of circumstances or a situation, which outcome is the best? And that case also confirmed that the power of the court to make declarations was essentially, actually, a parens patriae jurisdiction. So that's just a very brief history, bringing you up to the 2000s. And then what we had is the case of SA, and this really is the seminal case in respect of the inherent jurisdiction. It was a case heard by Mr. Justice Mumby, as he was then, and I've just included one of his quotes there from that case. It is now clear that the court exercises, in substance and reality, a jurisdiction in relation to incompetent adults, which is for all practical purposes indistinguishable from its well-established parens patriae or wardship jurisdictions in relation to children. And the court exercises a protective jurisdiction in relation to vulnerable adults, just as it does in relation towards a court. So, as I say, this really is the seminal case. You will see this case quoted in virtually every other case that comes within the inherent jurisdiction because it sets down so many of the fundamental principles and provides a huge amount of guidance. So I would recommend that you read this one in particular. So what Mr. Justice Mumby did really was to extend the scope of the inherent jurisdiction as it had sort of been rediscovered in the early 2000s. So he talked about the inherent jurisdiction no longer being confined to cases where a vulnerable adult was disabled by mental incapacity, and in fact it extended to a wider class of vulnerable adults. And the concept of a vulnerable adult is something that we'll come back to in a moment. Now, it's important to say that although this is very, very useful, Mr. Justice Mumby was very clear that he did not want to try and define exactly who might fall into this group, but he did try to give some indications as to the sorts of people and sorts of situations that might come to the fore. So you can see I've just highlighted part of what he said there. So even if not incapacitated, if a person is under constraint, subject to coercion or undue influence, or for some other reason deprived of the capacity to make the relevant decision. Just be a little bit cautious around the use of the word capacity there, because it's not what we think of in terms of mental capacity under the Mental Capacity Act. This is where people who are unable for whatever reason to actually make a decision. And you'll see again below, he gave some more indications and more examples of what he meant by the constraint, coercion, and so on. And I think this is very useful for practitioners, because if you're faced with a situation where you've got concerns, it may just guide you in terms of, are these the sorts of things that you're seeing and that you are concerned about? As I say, it's not an exhaustive list, it's not a tick box, but it might just give you an idea. So, for example, in the coercion and undue influence section, Mr. Justice Mumby was talking about where a vulnerable adult's capacity or will to decide has been sapped or overborne by the improper influence of another. And the inherent jurisdiction, sadly, is often used in situations which involve a vulnerable person and their relatives. And he went on to talk about where the influence comes from a parent or another close and dominating relative. It actually might not require very much pressure to have such a hold over that person. So it could be subtle, pervasive. It could be very little pressure required for that person to overbear somebody else's will. So as I say, these are the paragraphs that you will see cited in the majority of judgments from the inherent jurisdiction. Going along chronologically then, so that was in 2005, the case of SA, and then of course we had the Mental Capacity Act come into force in 2007, and there was some debate at that time as to whether or not the inherent jurisdiction survived the implementation of the MCA, and the short answer is yes, it did, and it does. So we had that confirmed in a variety of cases. There's a case of Mrs. Justice McCaw from 2010, LBL, RYJ and VJ, where she said, "I do not doubt the availability of the inherent jurisdiction to supplement the protection afforded by the Mental Capacity Act for those who, whilst capacitous for the purposes of the Act, are incapacitated by external forces, whatever they may be." And again, she cited the case of SA. And then more recently, in the case of, well, differently known as BF or Mayers, the Court of Appeal talked about the jurisdiction extending to protecting vulnerable persons who do not fall within the categories of those covered by the MCA, and further to providing additional protection to adults lacking capacity within the meaning of the MCA when the remedy sought does not fall within those provided for in the Act. So very much the inherent jurisdiction is still available, absolutely, notwithstanding the Mental Capacity Act. So one issue you may find arising is this. is if you have a case, you've got a situation that you feel needs the intervention of the court, do you use the court of protection or do you use the inherent jurisdiction? It's not always obvious. I'm going to refer to the individual concerned as X for the purposes of this presentation, so as not to confuse them with P that we use to describe the protected party in a court of protection case. So if X has capacity, you can't use the court of protection because the court of protection's jurisdiction is only invoked where a person lacks capacity to make the decisions. But sometimes you may have a situation where you don't actually know, you can't be sure about the person's capacity because you can't assess them, you can't get access to them. And that might actually be the reason why you want to go to court, because there's something happening, there's a situation arising whereby you are being prevented by somebody from having access to a particular individual. And so you might want to actually use the inherent jurisdiction to get access to that person in order to carry out a capacity assessment. One thing just to say though is this: think first whether you've got sufficient evidence to take you over the interim threshold for the court of protection. Now, whilst it's been made clear that even when looking at the interim position, there has to be a proper and careful analysis of the evidence, it is a lower threshold. And so if you've got sufficient evidence to take you through the interim ceiling, then you might want to use the court of protection. The other thing to say about that is this, and this is something that Mr. Justice Hayden said in a 2017 case, London Borough of Wandsworth. He said, "It would be unconscionable and socially undesirable if, due to the weaknesses of an assessment which failed satisfactorily to resolve whether there are reasons to believe the P lacks capacity, he were to find himself beyond the reach of judicial protection." And in that case, Mr. Justice Hayden said the starting point was a thorough MCA compliant assessment of capacity needed to be undertaken immediately. And when that report was available, he would revisit the question of capacity and therefore jurisdiction. But what he said was, "I am entirely satisfied that the inherent jurisdiction of this court permits P to be protected whilst those investigations resume." So that's an example where there was an issue with capacity evidence. Obviously, it was a situation where he had to think about what jurisdiction was going to be invoked, and he decided to use the inherent jurisdiction of the court to protect the individual whilst those assessments were carried out. You can also use the inherent jurisdiction whilst inquiries are made, and that's something we'll come back to also in a moment. So you will sometimes have cases which need to cross jurisdictions. So you may issue an application in the court of protection because you've got some evidence around capacity, and it later transpires that the person in fact has capacity but still requires protection, and then you ask the court to put their inherent jurisdiction hat on instead, or vice versa. You might not have sufficient evidence around capacity, so you start by seeking an order under the inherent jurisdiction, capacity evidence comes to light, and you're able then to transfer it into the court of protection. So when I say in the last bullet there about thinking about allocation, I'm talking about allocation of judges. So if you think that cross-jurisdiction is going to be an issue, you might want to flag that in an application just to say that that might be possible or might be necessary, and therefore you might need a High Court or a Section 9 judge who's able to hear both of those. So as I said, just come back to vulnerability, because the purpose of the inherent jurisdiction is to protect and support vulnerable adults who are unable to make decisions unencumbered. And essentially the question of whether a person falls within that category is one of fact. It's very useful, I think, to consider the examples given in essay. It gives you sort of a feeling and a flavour for the sorts of situations where somebody might be deemed vulnerable. because this is the inherent jurisdiction is not to be used simply because somebody's got a difficult decision to make and they're finding it tough. That's not what the inherent jurisdiction is for. This is very much for people that, because of circumstances beyond their control, quite often external factors are having an influence on their ability to make a decision or to exercise their own free will. It can be useful to get expert opinion. For example, if you've got somebody with a particular condition that, whilst doesn't make them incapacitous in terms of the Mental Capacity Act, it has such an impact on how they're able to function, live their life, make decisions, that you may want to get some evidence from somebody who is versed in that particular area. So, when might you find that you are wanting to use the inherent jurisdiction? As I say, it's probably most likely to be in circumstances of concern where X is being prevented from exercising their free choice or will. And as I say, unfortunately, that may be in situations where somebody is living with a partner or family. There may be concerns on the part of professionals because perhaps they're losing weight, or suddenly they're not attending day centres or activities that they had previously. Are they presenting with injuries? Is the person who's caring for the individual suddenly not allowing professionals to access? So those are the sorts of situations where little flags might be raised in your own minds. And of course, your concerns will be, is X at risk? What might those risks be? And it doesn't have to be, of course, a risk of immediate physical harm. It could be risks of, continuing emotional harm, being undermined, being isolated, being prevented from living their own lives. So if you are in a situation where you think that's happening and you feel action needs to be taken, I think one thing that's very important to consider is, what then is it that you're trying to achieve? What is it that you want to happen, or you want the court to order to try and resolve this issue? And one of the key principles, and I'll talk about it in a moment, is that the purpose really of the inherent jurisdiction is to be facilitative, not dictatorial, i.e. to put X in a position where they're able to make their own decision, unencumbered by external influences. So it might be that you want to gain access for the purposes of an assessment. It might be that you want them actually to be removed to a place of safety, but you need to be clear about what it is that you want to happen, and is it necessary and proportionate? You will need to be clear about what it is, or why it is that this needs to happen, and why this is the best way to make that happen. So just another quote from some case law, Lord Justice McFarlane in the case of DL, he talked about the use of the inherent jurisdiction being compatible with Article 8. He talked about any orders made by the court in a particular case must be only those which are necessary and proportionate to the facts of that case. So that's really some of the key things you need to think about. You want to be facilitative, and it needs to be necessary and proportionate. So what's your dilemma? Well, you might have concerns, but if this person is or you think has capacity, where are you drawing the line? Because a person who is on the face of it capacitous, who are you to interfere in their exercise of their own autonomy? Is it that autonomy is in fact being undermined by others? Are they making an unwise decision? Are they actually unhappy? Is there a risk of harm? You really will have to think about that, and Article 8 is likely to come into play, because, as I say, unfortunately, a lot of these cases do come about because of the relationships that X has with their partner, carers, parents and so on. But the courts have more and more been very keen to stress the importance of autonomy, and that it's not appropriate for the state to be over paternalistic and to interfere and so on. Of course, Mumby is the king of sort of trying to put that forward, and you'll all, I'm sure, be aware of the quote, his quote, that what use is making someone safe if it merely makes them miserable. And just to pick out a couple of things he said in the past, these are quotes from James Mumby. He said, in rescuing a vulnerable adult from one type of abuse, it might expose them to the risk of treatment at the hands of the state, which, however well-intentioned, can itself end up being abusive of her dignity, happiness, and indeed her human rights. And that's something to think about, particularly if you are looking to remove somebody from their partner or their family, and they, on the face of it, have capacity to make the decision to stay there. Another thing that James Mumby said was merely demonstrating that if you let that person go on living in that house, there is a foreseeable and appreciable risk that someone will come in and find them with a broken neck. Is that sufficient justification for making them leave if it's going to make them miserable? So this is the dilemma, isn't it? Where do you draw the line between autonomy and risks to the individual? And the reality is, what if something does go wrong? And I know that's something that's very much at the forefront of lots of practitioners' minds. Criticism if you fail to act when there are these red flags, but it very much is a balancing exercise. So I say balance the risk, not being overly paternalistic. And one point I think it is important just to remind ourselves, this is not about a subjective moral interference. Just because you or I might not choose to remain in a certain situation or choose to live our lives in a certain way doesn't mean that we should impose our standards on other people. But as I say, you have to balance that against the potential for significant harm and the impact on X if there is no intervention. So again, just some of the more recent case law, Mr. Justice Hayden in the case of Mayers said that however well motivated the state may be in seeking paternalistically to protect people from their own unwise decisions, it is a dangerous course which has the potential to threaten fundamental rights and freedoms. The inherent jurisdiction should be utilised sparingly. So it's not expected that whenever there's any kind of concern, you're straight off seeking an order under the inherent jurisdiction. Of course, local authorities have duties under the Care Act in relation to safeguarding, and that might be something, it's likely to be something that ought to be explored first of all. Having said that, if there are urgent situations, you might not have the time to do that. And in my view, in my experience, a local authority is unlikely to be criticised by the courts if there's a genuine and reasonable belief that an individual is at risk of harm, ongoing harm, and the local authority can show that the approach suggested and adopted is necessary and proportionate. So if you can evidence why you're asking for what you are, and that's objectively reasonable, I think it's unlikely that you'd be criticised. So I just want to go through some of the key points in a little bit more detail. And the first is this: statutory schemes come first, and that's why this is sometimes called the great safety net, because if there's a gap in those statutory schemes, in the legislation available, the inherent jurisdiction is underneath to catch anyone that falls through the statutory schemes. So it might be that action under housing law is more appropriate. It might be that Prevention from Harassment Act or the Serious Crime Act in terms of controlling and coercive behaviour are more appropriate mechanisms to address the issue or the risk identified. Having said that, I'm of the view that you don't have to go down that route in order to go to the inherent jurisdiction. In a case that Mr. Justice Cobb heard that involved Redcar local authority, this was an issue that was raised because it was said that there were alternative statutory mechanisms which could have been utilised by the local authority rather than bringing the matter to court. And Mr. Justice Cobb in that case said that he did not believe that the alternative statutory remedies would have offered the individual the level of protection she needed, and her cooperation with those processes was far from assured. So what I would say is think about it. If you don't think it's realistic, then I don't think it's a bar to trying to seek an order from the inherent jurisdiction, but evidence that you have at least considered it and why you've rejected it. Yeah, so again, going back to the DL case, the Court of Appeal, in which Andrew McFarlane endorsed a description which it was actually given in another case, the Westminster case, and he said, the terms of the statute must be looked at first to see what Parliament considered to be the appropriate statutory code, and the exercise of the inherent jurisdiction should not be deployed so as to undermine the will of Parliament as expressed in the statute or any supplementary regulatory framework. So again, there is an expectation that statute is used first, that you always look to that. But as I say, I don't think it's a bar if you can show that there's reasons not to follow that. Secondly then, if X has capacity, remember they are autonomous. And I know I'm sort of banging on about this point a bit, but I really can't overemphasize the point. If an individual has capacity, you are essentially asking the court to interfere in the life of a capacitous, autonomous individual. It's a very significant step. And really you should be looking at the least interventionist approach that you can in all of the circumstances, because albeit that you're likely to be trying to protect that individual, they may not see it that way, particularly if they have been under undue influence for a period of time, and what you're asking for might actually cause them distress. So it is something to be very, very mindful of. Next point, the facilitative rather than dictatorial approach. Again, it's something I've already referred to, but it's sort of the cornerstone really. The inherent jurisdiction is not there to sort of make orders to tell people what to do. It's there to protect people from difficult situations where they are being prevented for one reason or another from exercising their free will, and putting them in a position where they then can actually do that. So again, just a few quotes for you. And I will, by the way, at the end of the slides when they're sent out, I'll do a full list of all the cases that I'm referring to with the citations, so you've got a sort of a quick reference guide. So Mr. Justice McCaw in the RBL case said the relevant case law establishes the ability of the court via its inherent jurisdiction to facilitate the process of unencumbered decision making. And the facilitative approach was expressly commended by Andrew McFarlane again in DL, and he said that it enhanced rather than breached their Article 8 rights. And that's the point really, because you're trying to allow them the space, the time and the environment in which they can make their own decisions. And it was actually that case at first instance where Mrs. Justice Theus described the jurisdiction's primary purpose as to create a situation where the person concerned can receive outside help free of coercion to enable them to weigh things up and decide freely what they want to do. Moving on then, whilst I feel like I'm going a bit quick, maybe I need to slow down so you can keep up with me, sorry. Whilst inquiries are made, this is quite an interesting use of the inherent jurisdiction, and again, I've referred to it briefly already. It may be that you're not quite sure of the situation and you need to put a stop on something, or you need to maintain a status quo whilst you gather further evidence. And that might be around capacity. It might be around vulnerability in terms of trying to identify whether the person is in fact vulnerable in the SA sense. You know, if you've only got a very small amount of information, or a few comments have been made, or there's little bits and pieces from GPs or other family members or so on, it might be that you don't really know yet what the position is, and you need some time and some space to try and understand what's happening on the ground. Is there an issue around how X has been, or the situation in which X finds themselves, and the environment that they're in. So again, Mr. Justice Cobb in the Wakefield and Dieng case talked about if the evidence indicates a prima facie case, so on the face of it, it appears that someone is vulnerable, and justifies the necessity and proportionality of an order, it's entirely proper for the inherent jurisdiction to be invoked as an interim measure while proper inquiries are made, and while the court ascertains whether or not an adult is in fact in such a condition as to justify the court's intervention. So again, just when you're coming to that balance of whether it's appropriate to seek an order from the inherent jurisdiction, you're not expected to wait until something terrible's happened. You're not expected to, you know, gather every single tiny piece of evidence that may be possible to obtain. If your concerns are so significant and you do have a reasonable belief that there are issues, but you need to explore that further, you can use the inherent jurisdiction for that. It might just inform quite what you're asking for, or the time frame that you're asking for. And again, Lord Justice McFarlane said that he rejected the inherent jurisdiction was limited to providing interim relief designed to permit the vulnerable individual the space to make decisions removed from any alleged source of undue influence. He said that some interim provision may be of benefit in any given case, but he rejected that represented the totality of its powers. And it's sometimes been suggested that that's all the inherent jurisdiction should be used for, just to give the person that space to make the decision. Andrew McFarlane's making clear that yes, that is a use of the inherent jurisdiction and it can be entirely proper, but that's not the limit of its powers. One interesting issue that's arisen in the past has been whether or not the court should make injunctions against X, against the vulnerable person themselves. And it was the Redcar case in which Mr. Justice Cobb had cause to look at that in some detail. Though he actually relied on quite an old case called Wookie and Wookie from 1991, which was to do with a married couple. I think it was some sort of restraining order or seeking to prevent an abusive husband returning to the property. And Mr. Justice Cobb applied the principles that had come about in the Wookie and Wookie case in respect of the Redcar case. And what he noted really was that injunction is a discretionary remedy. It's something that court can implement if necessary. But it was very important to look at whether the person against whom you're making that injunction actually understands it. And I suppose it follows, doesn't it? What use is there in making an injunction against somebody that doesn't really understand what it means, that you're not going to be able to enforce it against, and realistically a court is never going to go through with any kind of punishment if they fail to abide by it, if they simply don't understand its terms. And so what Mr. Justice Cobb said in Redcar was, although he was conscious that there was precedent in judges making orders against the vulnerable adults themselves under the inherent jurisdiction, he felt that it had been illogical in the Redcar case, basically for the court to come to a conclusion that she needed protection from the court, and yet the court was also ordering her, or making an order to stop her doing something that she wanted to do, and then backing that with the punitive force of an injunction. So I think what we can take from that really is, whilst it is a course of action available, it's not one to be taken lightly, in the sense that you'll need evidence. If you're seeking an injunction against the vulnerable person, you'll need evidence that they can and could understand it, that they understand the terms of it, what's expected of them, and what might happen if they were to breach that. And I think there is something in there, isn't there, about you, to protect somebody, you're making an order to stop them doing what they want. And it goes back to some of the principles we've already talked about. So just in terms of some practical considerations for you when you're faced with a situation where you're thinking about the inherent jurisdiction, think about your capacity evidence first. Have you got it? Do you need it? Is this something where you need to look at the court of protection? Is it something you need to look at cross jurisdiction? Have you got enough to get over the interim hurdle for the court of protection, or are you not there? Is there an alternative route? We've talked about potential of the statutory schemes. If you don't think there is, or that it's suitable, just set out that you've considered it, and either you don't think there is one, or it's not appropriate to use it for whatever reason. What do you want the court to do? Be precise. Think about the purpose. Think about trying to facilitate the vulnerable person themselves making their own decision. That ought to be your underlying position, certainly at the outset. But again, be precise. How long do you want this order? What is it going to achieve? What are you going to do at the end of that period? Apply the principles. So again, you're going back to your fundamentals of necessary and proportionate. Is there a different way in which you could achieve the same outcome that's less distressing to the individual, less restrictive? And I'm straying into MCA principles, but some of those are really important just to read across. And then just a short point on ex parte applications. So that's applications without notice. It may be you're in a situation where it becomes clear that someone's in a situation where there's imminent danger of such a degree that you actually need an urgent order from the court, and you don't actually want to give notice either to the person themselves or the people around them. That's something you'll need to think very carefully about. Obviously, you'll take legal advice, but you'll have to present a very clear and robust argument for that, particularly if you're asking the court to do something quite significant that's going to turn someone's life upside down, and it's more likely than not that they actually have capacity to make decisions around where they're living, for example, or who they're having contact with. So just be aware that if you're going down that route, you want the best evidence you can. So what happens then if you've had a situation, you felt that someone's needed protection, you've gone to the court, you've been granted an order to, say, remove this person from the situation, they've had a number of weeks away, they've been supported, they've been given education maybe, they've spoken about the issues to somebody, they've been having no contact with the people that are said to have been coercing them or controlling them. Where are you then? Well, if they've got capacity, you may just be in a situation where you've given them the opportunity to make the decision, they've made it, you might not think it's very sensible, but what basis have you now got to ask the court to do anything? I had a case, for example, in front of Mr. Justice Cobb a couple of years ago, where there was a mother and son who lived together. It was what some might say a rather unhealthy, codependent relationship. They both had their own needs, they both had care packages, they both had litigation friends during the course of the proceedings. And the social work team had become very concerned that Mum just wasn't letting the young man live his life. She was sort of ringing him constantly whenever he left the house. She was sort of encouraging or discouraging him from going to day centre activities. And the local authority had been granted an order to place this young man in a supported living placement for a period of time to remove him from that situation, to see if actually he did want to go back, because there'd been some question marks as to whether he still wanted to live with her, and that evidence had been very inconsistent. So he'd been away for a while. We had the hearing, and it was the hearing itself was the first time the two of them had seen each other in quite a number of weeks. And I have to say it was rather emotional, actually, because the first time they saw each other was actually in the courtroom itself, and we were all left sort of standing to the side for a little while both of them broke down in tears, clung on to each other. And it was very clear that for all we may have felt it wasn't the healthiest of situations, they very much wanted to be back living together. And the judge held in that case that the young man had been given every opportunity to make his own decision. He had capacity to do that. And his decision then was to be supported, and there was nothing that the court was going to do to prevent that. So it's right that people are given that opportunity. It's right that people are removed, or rather undue influence is removed from people to allow them to do that. But it might be that people will still go on to make unwise decisions, and people are entitled to do that, as we know. Just a reminder, I know you know this, but just to say, even if that sort of situation happened, that doesn't then absolve local authorities from their other duties. So you'd still be required to carry out your Care Act duties in terms of assessing and meeting needs, in terms of safeguarding, and so on. One thing I want to spend just a little bit of time talking about is this, and that's the inherent jurisdiction and deprivation of liberty. It appears, I say this with a slight hesitation, and you'll see why in a moment, it appears that the inherent jurisdiction can't be used to deprive a person of their liberty, but it may be able to restrict it. And two of the cases I want to talk about are these, Mayers and Wakefield. As I say, I will put the full list and the citations when the link goes out to you, probably tomorrow. So the case of Mayers was a case heard in 2018-19. You may remember it received quite a lot of publicity, and there were a number of hearings that the case evolved somewhat over the months. And it was a case where a very elderly man, I think of 98, lived with his son, and they were described as having somewhat of an enmeshed relationship. But there was evidence that the son wasn't caring very well for dad. They were living in sort of squalid conditions, and the local authority were understandably very concerned. In that case, Mr. Mayers certainly lacked capacity at one point. That seems to be as a result of dehydration and a UTI, and so orders were made in terms of him living in a care home for a period of time. What then happened though was he recovered from those physical issues and was found to be capacitous in the relevant areas. But what was interesting was Mr. Justice Hayden didn't allow him to return home at that point, and in fact made orders that Mr. Mayers was not to return home, was not to live with his son, and was to live at a care home, or the care home, or another place that he and the local authority agreed. So you've got issues there with orders being made against the person themselves. You can see quite clearly the rationale for that. If there was poor care or abusive experiences for Mr. Mayers at home, you could understand why the court would be concerned. But permission was sought to appeal that decision on the basis that there was no evidence that Mr Mayers was of unsound mind. And of course you'll be aware that Article 5 provides that everyone has a right to liberty and no one should be deprived of their liberty unless it's in accordance with a procedure prescribed by law. And for the purposes of the work that we're doing and we're talking about today, that would be around a person being of unsound mind. Interestingly, the permission to appeal was refused by Lord Justice Baker, and on the basis that there was, on the face of it, some evidence that Mr Mayers might be of unsound mind. And Lord Justice Baker quoted from the famous case of Winterwerp and Netherlands, which provides that in an emergency situation, a person may be deprived of their liberty in the absence of evidence of a mental disorder without infringing Article 5. So that was the basis of refusing the permission to appeal. But it's important to note that notwithstanding that, Lord Justice Baker also emphasised that in circumstances where someone is found not to be of unsound mind, they cannot be detained in circumstances which amount to a deprivation of liberty. It's quite interesting because Mr Justice Hayden ultimately found that Mr Mayers was entirely capable, had capacity, and did not satisfy the criterion of unsound mind, or in fact was suffering from mental disorder. But he still wouldn't allow Mr Mayers to go home because he wanted the son out first. He essentially said that yes, Mr Mayers may go home, but it's conditional on his son being excluded. And what Mr Justice Hayden said was that this was a restriction on Mr Mayers' autonomy and a proportionate interference with his Article 8 rights. And what he said was happening was Mr Mayers' choices were being restricted only, not his liberty. And so it didn't breach Article 5. That's quite interesting if you compare that to some of the other case law. So again, going back to the Red Car case, Mr Justice Cobb was considering the deprivation of liberty point, and he referred back to a judgment of Justice Mumby of JE and DE, where the local authority in that case had no objection in principle to DE living somewhere other than a particular place, for instance, with his daughter or some other establishment. But what Mr Justice Mumby said was that fails to meet the charge that he's being deprived of his liberty, because he was being prevented from returning to live where he wants and with people that he wanted to live with. So it's quite interesting to sort of look at those cases next to each other. And certainly the case of Myers has not been wholeheartedly endorsed in cases that have followed. And as I say, there's the case of Wakefield, which was another case heard by Mr Justice Cobb in September of 2019. And in that case, the individual was not a person of unsound mind. And the parties actually agreed in the end that the inherent jurisdiction couldn't be properly deployed to authorise a dole and a deprivation of liberty. And there were limited circumstances in which that could be appropriate. And it was held that they'd been accurately described by Mr Justice Mumby in the case of PS. And what was said in that case was that if the inherent jurisdiction is to be invoked to justify the detention of somebody, then there are minimum requirements to satisfy Article 5. Fundamentally, the evidence must establish unsoundness of mind of a kind or degree warranting compulsory confinement. So in other words, there must be some evidence establishing, at least on the face of it, that the individual lacks capacity. So these really have reinforced that you can only deprive someone of liberty if they are of unsound mind. That was described again in the case of Winterwerp and has been interpreted in a number of cases in England, that the person must be reliably shown to be suffering from a true mental disorder, established on the basis of objective medical expertise. The disorder must be of a kind or degree warranting compulsory confinement, and the validity of continued confinement would depend on the persistence of such a disorder. So you need some evidence that that is right, that that is the situation, if you're wanting to deprive someone of their liberty. And the inherent jurisdiction is only going to be used probably whilst that is properly explored, or on an emergency basis, which, as you've heard Winterwerp said, is possible without full evidence. But if you then find that someone is not of unsound mind, you cannot use the inherent jurisdiction. So some final thoughts then. There's various uses for the inherent jurisdiction. It might be to obtain an assessment whilst inquiries are made, either as to capacity, vulnerability, and so on. It could be to remove somebody from a situation to facilitate their own decision making. But it can be difficult, and it really often is a judgment call. It calls for the faithful application of the principles. It calls for consideration of the matters raised in the case of SA. It calls for you to balance, we talked about, the risks against autonomy, against the background of the information that you have. But what I would say is, if you are concerned, look at these principles carefully, look at the guidance carefully, and think about what it is you're seeking from the courts in order to achieve the best outcome for that vulnerable individual. So thank you all very much for your attendance. If you want to put any questions in the chat box, I'm happy to try and answer them now. Otherwise, if you think of anything else, please feel free to contact us in Chambers. As I say, we'll be sending out a link to a recording of this seminar probably tomorrow. You'll get a copy of the slides, and as I say, I'll do a separate sheet which just has details of all the cases that I've referred to and their citations for your reference. But thank you all very much for coming, and I'll just see if there's anything in chat box if I can find it. Maybe not that one.